eighth episode of the Binary Agora, and in this series, we dive deep into the world of legal tech, breaking down its challenges, its innovations, and also real world impact with insights from top researchers. And today, we are going to go outwards and in trying not to be too Eurocentric in our approach towards analyzing digital regulation. I have invited to join us today Shilpi Bhattacharya. I hope that's correct, who's a professor at Jindal Global School of Law in India, and she teaches and researches competition law, digital markets, law and economics, and also rare disease policy. And she has also written extensively about competition law being applied in India and how those cases have also presented novel theories of harm in terms of the discipline as we know it now. So, welcome to the channel, Shilpi.
Thank you so much for having me here today, Alba. It's such a pleasure to be here. And also, thank you for all the wonderful work that you are doing in this area.
I believe that you're going to present like two really important cases within the design and the enforcement of digital competition coming from the Indian Competition Authority. So the floor is yours.
Thank you so much, Alba. So I thought we can talk about some of the recent developments with respect to competition law enforcement in the Indian digital markets. But also, obviously, there are very interesting parallels with what's happening elsewhere in the world. And it's interesting to see how India is approaching it, especially how the Competition Commission of India is approaching it vis-a-vis sort of how other regulators and enforcers are approaching these issues. So I thought that there were two sort of very interesting and relatively recent cases before the CCI and the Appellate Tribunal, which is called the National Company Law Appellate Tribunal, or the NCLAT. So the first case is on app stores. And we know that app stores are a big area of contention, and there's been multiple cases in multiple jurisdictions with respect to the distribution of app stores, as well as these anti-steering provisions that Google and Apple are imposing on app developers. So we had a case on those issues in India. The Competition Commission of India, or the CCI, started investigating that case in 2020. The CCI gave its final order, finding Google had abused its dominant position in the market for App Store distribution. They defined three markets: OS, operating systems, app stores, and the market for a certain kind of payment system which is unique to India, which is called UPI. That order was appealed in 2025. The Appellate Tribunal gave its judgment, which we'll talk about. But what is more interesting is what happened after the Competition Commission's order came out in 2022. And then a bunch of app developers and asked the CCI to investigate the compliance that Google was offering after the order came into place. Primarily, the issue is that Google is forcing app developers to adopt its billing system, which is the Google Play billing system. If you want to be on the App Store, you have to adopt that system. The second issue is the anti-steering policies. Google does not allow app developers to direct consumers to other ways of making payments. You can't have links offering other ways of accessing the app, etc. And I think this issue has been pretty much in many jurisdictions found to be problematic from a competition law perspective. But then the other two issues, which we'll talk about today, slightly more interesting. One is that the CCI also found that Google was discriminating between its own apps and other apps. For instance, YouTube does not have to use Google Play's billing system, and Google doesn't charge it 15 to 30% commission that it charges other app developers. And finally, the other interesting issue was the high commission rates, which to me is really the core issue in this case. Because even if and we've seen this with the compliance, if Google does offer steering towards other sources, but it keeps those app commission rates very high, given that we don't still have effective alternatives in the market, the high commission rates still do not really solve the problem for app developers, is my view of it. Here, the commission did not find against Google on the high commission rates. So the mandatory imposition of Google Play's billing system and the anti-steering policies, which I think even in the US, which has a more sort of conservative approach, they did find that the anti-steering under the California laws was problematic. And in India, the appellate tribunal agreed with the CCI that this is problematic. But the reason why they said that this is problematic is because it is unfair to app developers and to consumers. So it's more of a exploitative abuse of dominance type of position. And the idea is that Google, given its position of power, should allow developers and consumers the right to choose alternatives. And here the appellate tribunal said that Google didn't is harming both app developers and consumers by not giving them the freedom to choose, but also that Google could not really justify why they were doing it within a certain provision in the Indian Competition Act, which allows them to justify using unfair or discriminatory prices or conditions in their contracts. And the justification is called the meeting competition defense, which is that if you're doing this to meet competition, then it's justified, but Google couldn't justify it on that ground. And then the other point was the point of discrimination, which I think has not come out in too many other cases, which is that Google does not charge these commission rates from its own apps, and it does not subject them to mandatory usage of its billing system. And I think here maybe the CCI could have come up with a margin squeeze type of theory, but they didn't, which I think is a lost opportunity because they got reversed on appeal because the appellate tribunal said that there is a justifiable reason for discriminating between Google's own apps and third-party apps because these are Google's own apps. So it's not unfair to discriminate, which is very interesting rationale because the future of margin squeeze cases becomes a bit questionable in Indian jurisprudence. And then the last interesting point here was the point on excessive pricing, which is that the commission rates of 15 to 30% that Google is charging from app developers is unfair. And the Competition Commission said that we cannot comment on the fairness of this commission rate. And we know that a lot of competition regulators do hesitate, even if the law allows them to make that kind of determination because they don't want to be price regulators. So here as well, the CCI said that Google could be making money in a number of different ways, and we don't fully understand Google's monetization model. So we don't have enough information to say that this rate is excessive. So they didn't really find that to be abusive. But at the same time, they made this very interesting statement in the order where they refer to Google as a gatekeeper. And they say that gatekeepers should impose fair, reasonable, and non-discriminatory prices. That Google kind of latched onto that concept of a gatekeeper and argued before the appellate tribunal that the usage of the word gatekeeper suggests that the directions of the Competition Commission in this order are more in the form of ex-ante regulation, and they should not be doing ex-ante regulation because that's not their job. So that was kind of interesting also because I think when CCI uses this term gatekeeper, I don't think it's actually referring to any kind of ex-ante regulation. But it's interesting how this has permeated kind of our jurisprudence here. Our draft digital competition bill doesn't refer to the term gatekeeper. Because the CCI did not find that the commission rate was excessive, the appellate tribunal did not have to look into that issue, but they did say that you cannot use your ex post jurisdiction to enforce ex-ante regulation. And that kind of brings me to what I found to be interesting in this case, which is that the CCI did not say that this commission rates were excessive. Now, what happens is that after this order comes out, as I mentioned earlier, a bunch of app developers go to the CCI and they're not happy with how Google is complying with this order. So in response to this order, in order to comply with it, Google implemented this user choice billing system. That was essentially the same thing as the previous system, but it allowed app developers to use other payment processors. And if they did use other payment processors, then the commission rate would be lowered by 4%, which is again a rather high commission rate to pay. So in in this request for an investigation that was made before the CCI, it's a separate case. But now the CCI is going to investigate specifically on whether the commission rates are unfair pricing. So whether that is an exploitative abuse of dominance. So now the CCI is going to look into this. And that is why I feel that maybe the commission rates were really the key aspect of the harm from this kind of conduct, because even if you address the anti-steering part, if the commission rates are still going to be this high, it doesn't really help app developers in this entire kind of situation. So therefore now the CCI has to go back and investigate whether the commission rates are high. So I think they should have just done that maybe in the first order, because that is really the key, in my view, to the anti-competitive conduct in this case. And if we don't address that, we're not really addressing what is really problematic for app developers here. What do you think in terms of the parallels between this case and what's happening in the DMA?
So I just had a question for clarification. Stemming from the decision issued by the Indian competition authorities, there's a separate proceeding going on relating to the unfair pricing based on the way in which Google presented its compliance as a consequence of that decision. Is that right?
Correct.
Okay. When you were speaking and as you were discussing the theory of harm that the Indian Competition Authority introduced, I believe it already had like some common themes with what we already saw before the DMA was enforced and with the DMA's enforcement, especially relating to how we interpret this concept of fairness. So I was wondering, and this is something that the European Commission has also done now, especially with regards to anti-steering, not for Google, but rather for Apple on its recent case, and it has also developed that theory of harm that it had not really used for some time now regarding the definition of the unfair trading and conditions imposed upon those developers. So I was wondering how the Indian Competition Authority also interpreted that broader notion of unfairness and whether fairness is really incorporated within the digital competition bill, or do you see it more as an instrument for the Indian Competition Authority to apply it within different types of exploitative theories of harm?
The first obligation in the draft digital competition bill in India is an obligation relating to fairness and transparency. And it's quite broadly worded as it stands right now. Fairness is also part of the preamble of the bill. It's clearly very key aspect of this bill, and actually fairness is a key aspect of Indian competition law, because a lot of people actually refer to the CCI as a fair trade regulator. A lot of CCI orders do come in under the first abuse of dominance provision in the Competition Act is on unfair terms and unfair pricing. In this case, the CCI was particularly troubled because of Google's market power in the Play Store market, because essentially Apple iPhones are not that popular in India. So Android phones are overwhelmingly what Indians use. So Play Store then has a very, very significant position in Indian markets, and app developers have to therefore distribute their apps through Play Store whether they like it or not. So the CCI was very cognizant of that, and I think the Appellate Tribunal was also very cognizant of that. And therefore they say that when you have that kind of position in a market, you are required to give your users that kind of options. You can't sort of force them into doing these kind of things.
I was wondering whether, although you have these references and these statements to unfair terms and practices and fairness and transparency, you have a workable definition of fairness within the Indian competition law regime, or does it remain undefined so that it is also more feasible for the CCI to apply it transversally throughout different theories of harm?
We don't. And it's just not only for fairness. In general, Indian competition law is, I think, kept a bit more vague. So for most of our sort of abuse of dominance jurisprudence, we don't have a very defined set of principles or even definitions that we refer to. It's quite a fluid jurisprudence that we have. The CCI adapts itself with each case that it's investigating. So I think that is obviously done deliberately. But at the same time, I think the CCI is very cognizant of the degree of market power when it does look into fairness.
The last question on this tenet of fairness. So would you expect this influence concept applied within competition law rules in India to be transposed or translated to the digital competition bill in the same terms? Because in Europe, we have this dichotomy where fairness, and the European Commission stressed this within its Apple music streaming case, saying fairness within competition law is not the same as fairness within the DMA, but in turn, it also interprets the unfairness of the training conditions imposed by Apple relating to anti-steering with reference to the DMA, and how the same obligation, so the obligation to not impose anti-steering, was inserted within the DMA. So do you expect to be there a dichotomy, or do you expect them to be like two kinds of pathways, one slower if you want and one quicker in terms of procedural safeguards?
Unlike the DMA, the draft digital competition bill is supposed to be competition law, right? So I think, just this is a speculation, but I think that the same jurisprudence will apply to the way that the CCI interprets the provisions. And also, the draft digital competition bill, the obligations are supposed to be set out separately for each designated entity with respect to the core platform service that they're providing. So there will be some clarity in terms of, say, how do you comply with the fairness obligation, is what I'm guessing. But I think here in this order, the CCI tried to kind of sneakily put in this FRAN requirement into the Play Store case, and that didn't work out for them.
On this note, there's the DMA established this Article 612, which really applies these FRAN conditions on app stores, for instance. So would you expect some kind of impact to be produced from the EU to India in that respect, of maybe replicating compliance strategies coming from from Google, or do you believe that they are going to remain more defiant?
The CCI very closely monitors what's happening in other jurisdictions, and particularly in the EU. So we see this constantly reflected in a number of the orders. And also, if you see what's happening now with the effects-based approach coming into Indian competition law, the jurisprudence is entirely sort of, the references of the Indian Supreme Court are taken from EU cases. So you can see very clearly the kind of impact that EU jurisprudence has in general on Indian competition law. And so I do expect definitely that the CCI will take ideas from the DMA with respect to its own implementation of such a regime, because it doesn't have the capacity to make up entirely from scratch its own way of doing this. So it's definitely going to borrow from these jurisdictions. But then there's also a lot of pushback in India about just blindly borrowing and the whole Brussels effect. So it might have to address that pushback a bit as well.
We can move on to the second case that you wanted to present, and it's also quite similar to the obligation imposed under Article 5.2 of the DMA, which really prohibits this cross-using and combining personal data across core platform services, building upon the Facebook case brought by Germany. In India, you had a similar case, and I believe the comparisons and also the similarities are going to be quite striking, or maybe not.
CCI order came out last year. So this was CCI's own investigation in 2021, because in 2020, TAP introduced this new set of privacy terms, and all of us in India got this pop-up from WhatsApp saying that you either agree to sharing your data with the Meta group of companies, or you stop using WhatsApp. Right? That was the choice that we were given. And of course, you didn't have to make that choice immediately. You could kind of skip it, but that was the choice. So the CCI references this as a take it or leave it provision. CCI found that to be problematic. And so they started investigating, and then there was a bunch of petitions filed in different high courts, and finally went up to the Supreme Court of India, saying that CCI did not have jurisdiction to investigate this matter because it dealt with privacy. Privacy is a constitutional right in India, and also we have a bill, but now it has been enacted into an act, a privacy law. So there was a lot of litigation that tried to stop the CCI from investigating this, but CCI won all of this litigation, and then finally last year it gave its order finding against WhatsApp, and that WhatsApp abused its dominant position in this market. So now we're awaiting the appeal, but there was an attempt to stay the order before the appellate tribunal, and some parts of the order were stayed, but not all of it. And the CCI jurisdiction was definitely not considered to be an issue in this case. So that was a big win for competition law in India, that the CCI can assert its jurisdiction on privacy matters, especially now that we have a law. The CCI says very clearly in this order that its jurisdiction is different from the jurisdiction of a privacy regulator, and it needs to exercise jurisdiction with respect to data related matters in digital markets because of the critical role that data plays in digital markets and how it can be used as a key tool to strengthen and sustain market power in digital markets. And here also the CCI draws very significantly from EU jurisprudence. And when it says that there's now consensus that privacy is a non-price parameter of competition, it's primarily referring to EU jurisprudence to make that claim, because this forcing of data sharing onto WhatsApp users is a reduction in the quality of service provided by WhatsApp, and therefore it is an abuse of dominance. So here the CCI looks at this from two perspectives. So it's both an exploitative abuse and an exclusionary abuse according to the CCI, which also is, I think, interesting because we see that kind of exploitative abuse versus exclusionary abuse dichotomy in some of the EU jurisprudence on data privacy and competition law as well. Essentially, because of this very peculiar nature that this kind of privacy update was kind of forced onto consumers in a take it or leave it manner, the CCI said that this is coercive because you don't have a choice with respect to whether to use WhatsApp or not because of the significant network effects and position that WhatsApp has in this market. So because of that significance, you can't just force consumers into this privacy data sharing requirement. And also the CCI found problematic the nature of the language used in WhatsApp's privacy policy, saying that it's exceptionally vague and it's not transparent, and it allows WhatsApp to collect a lot of different kinds of data. Even if it's not actually collecting it now, it can collect it later. So it gives a lot of power to WhatsApp to do a lot of different things, to collect a lot of different kinds of data. And the CCI also noted that WhatsApp is not doing that in EU. So because of the GDPR, WhatsApp's privacy policy is much more transparent in Europe compared to India. So they say that this shows that WhatsApp is doing things that it doesn't have to do, but it's doing it because it can do it in India. So essentially, they find this degradation of quality because of the take it or leave it nature of the clause and the kind of data being collected, the extent of data being collected, as an unfair imposition of terms on consumers and therefore an exploitative abuse. On the exclusionary abuse claim, they essentially say that this will strengthen Meta's ecosystem. So essentially, the data collection and aggregation of data across the Meta group of companies allows Meta to strengthen its display advertising market, and that will allow it to offer much more precise, targeted advertising that are more centered on consumer insights. Who do not have the ability to collect that kind of data will not be able to compete effectively with Meta in the display ad market. And therefore, this is a denial of market access to competitors in the display ad market. The first remedy that the CCI said was that you cannot, WhatsApp, you share your data with the Meta group of companies for a period of 5 years. And that has been stayed on appeal, because the appellate tribunal felt that if we do that, then Meta's entire business model, which is centered around advertising, will collapse. So they did state that remedy. But there are a number of other interesting remedies where the CCI has asked for the privacy policy to be made clearer and more transparent for consumers. But there's no sort of pay or consent type of model in these remedies, which also I thought was interesting. So your thoughts on this, Alba?
I was also thinking, and we commented on this earlier when we were preparing the episode, about now WhatsApp has also announced that it's going to roll out globally this account center that it already offered within Facebook and Instagram, to ask users whether they want to combine data across its platforms. The updates section of WhatsApp will be able also to deliver advertising to its users. So it's also, I would say, quite similar to the continuum that we are seeing with WhatsApp's compliance strategy and compliance proposals within the Indian environment. And also had in mind because the CCI is, or you can also provide clarification on this, also a consumer protection authority.
No.
It's not. Okay. For instance, the Italian Competition Authority also had a similar case relating to these really opt-out privacy policies that I believe Google was proposing, and it used its consumer protection mandate to argue that Google's practices were coercive and aggressive. So I was also wondering how the CCI really justified the use of these concepts that really belong to consumer protection more than competition law.
We have this very strong kind of jurisprudence around exploitative abuses of dominance. So here, the CCI said that this is an imposition by a company that is able to do it because of its position in the market, its power in the market. Because of that power, there is an inequality in the bargaining power between users and WhatsApp. And because of the network effects, users will not switch to alternatives even if they want to. So they are kind of forced into doing this. And because of the market power, they are being forced into doing this. If the market was competitive, WhatsApp could not have gotten away with this. This is a direct result of the market not being competitive, and therefore the CCI is stepping in to try to fix this.
On the exclusionary tenets of the case, so I was also really interested in hearing about the fact that the CCI introduced this ecosystem-based theory of harm in EU competition law, and in other jurisdictions, ecosystem seem to be quite of a buzzword, but we really do not know or have applied in practice in those cases what ecosystems really mean. So ecosystems are not an aggregation of services, but rather a distribution of weights within a set of services within a platform that is governed by the ecosystem holder. So the repercussions of one, I would say, letting one of the pieces of all of the machine fall can be quite grave, as opposed to other types of services that operate in a traditional manner. So I was wondering how the CCI also used this concept of ecosystems within the case.
I absolutely agree with you that we don't really have a very clear understanding of what an ecosystem really means. So obviously the CCI does not go into what is an ecosystem, essentially saying that because of the set of services that the Meta group of companies provides, it can benefit much more from this kind of accumulation of data. CCI refers to this term cumulative effects that strengthen its position in the market because it works as an ecosystem. So essentially comparing this ecosystem to individual competitors, because the CCI takes a lot of feedback from other sort of big tech players like Google, Amazon, but also from smaller players that provide display advertising, who are clearly not ecosystems because they have maybe only providing display advertising. They're much smaller players. And saying that sort of these players cannot really compete against the cumulative effect of the precision obtained from this kind of data that is being aggregated by the Meta group of companies. Yeah. So it's more about the cumulative effect.
Okay, so not so much ecosystems. So ecosystems is already, and also within this case, used as a buzzword more to maybe attract some attention rather than observe like the latter repercussions of what an ecosystem means. And I am like really engaged with this topic, especially because I also research on this for my thesis. I'm surprised by how competition authorities are trying like to instrumentalize this concept of ecosystems, but they do not really seem to get like through with it and nail down how governance works within platforms, which is much more complex than it would seem from that perspective. And you could also provide us a view of how the payer consent model would be regarded from the Indian perspective.
But also just coming back to the ecosystem thing, they also said that basically this data is going to help Meta across all of its companies. So it's not just about how it will help sort of display advertising, although that's the market that's defined in this case, but they say that it will help Meta to provide better services and strengthen its position across its different the different markets in which it operates. So they also generally said that. CCS has a lot of things more generally, but I just wanted to add that. I think that also was like why they were referring to an ecosystem, but ultimately they have to show the effects in the market that they've defined, and they also have been doing that very vaguely. I didn't talk about that in the Google Play case, but a lot of their Google Play paths that were overturned were because they hadn't properly defined markets and shown harm in those markets. So they've also been a bit vague about doing that. So I just wanted to add that in. Pay your consent, great question. Not sure how CCI would view it, but I think at least it offers the choice, which is, I think, what CCI is looking for, like some level of choice. Under the DMA, that model is problematic, but I think from just the only basis I have for making a comment is what CCI found to be problematic in this case, which is that you're giving absolutely no choice for someone who doesn't want to share their data, including people who opted out of sharing their data in previous policy updates will now have to share their data. So if you're giving a choice to consumers and that's an effective choice, I think CCI would be happy with that.
And by the way, on the remedies and the fact that they did not accept the fact that WhatsApp would not be able to share its data with other platforms. So that's basically what's happening with Article 5.2, and Meta has some grip over the advertising market. So I do not know whether the courts may also regard those impacts as a justification to impose those same remedies. There's also this sense that the DMA may also permeate not only within like the replication within other jurisdictions, such as in Brazil or in Australia, in the creation of these ex ante regulations, but also with the replication of its theories of harm and its obligations. So I would say that that will be really interesting to watch. And on that note, within the deliberate vagueness that the CCI introduces within its cases, and with the really interesting discussion that I had with Shilpi, that's a wrap for the episode. And if you have any thoughts or any feedback, drop a comment below.
Thank you so much for having me, Abba. This was such a fun discussion, and always love to hear from you about all of these issues.